overarching legal framework, what exists, and why the gaps in this legal framework really point to the need to having a public trust doctrine extension to protect groundwater resources. So as you can see from this slide, when we're talking about groundwater and aquifers, where groundwater comes from, there are two basic kinds of aquifers. You have confined aquifers and unconfined aquifers. Confined aquifers are exactly as they sound. They're overlain by a confining layer so that in order to access the groundwater in the aquifer, it must be released somehow usually by wells. And then the second type of aquifer is an unconfined aquifer, and this is directly connected to surface water so that the water table in the aquifer moves up and down with changes to surface water. And here you can think of the springs in Florida or spring-fed rivers or lakes as the aquifers that contribute groundwater to surface waters. And here there's a very clear connection to navigable waters, making the extension of the public trust doctrine to groundwater protection much clearer and easier. Here is just a map of kind of a map of all the aquifers, principal aquifers in the United States. So as you can see, aquifers are important everywhere. Groundwater resources are important everywhere. Among the notable ones, you have, I don't know if you can see it, but number 10 in California is the Central Valley Aquifer System. You have the Ogallala Aquifer System, number 11 in blue in kind of the Midwest Central United States. And then in Florida, you have the Floridan Aquifer, it's the kind of tan one. And that provides the overwhelming majority of drinking water to Floridians. So groundwater is a very important resource both for industrial use, agricultural use, and public supply. As of 2015, the last year for which the data are available, their total water use in the United States was about 280,000 million gallons per day. And of that, about 30% was groundwater and 70% was surface water. In terms of groundwater, the vast majority, 70% of fresh groundwater is used for irrigation in states, primarily in states like in California, Arkansas, Nebraska, Idaho, and Texas. And then the second largest use of groundwater is public supply. But public supply dependence on groundwater varies across the country. So in states like Hawaii and Idaho, Florida, Mississippi, Iowa, and Nebraska, those states relied on groundwater for more than 75% of their public supply withdrawals, and that includes domestic and drinking water uses. The pressures on groundwater resources are increasing every day, especially with climate change. There's natural contamination from radioactivity, arsenic, saltwater intrusion, but also human sources of contamination, leaks from underground storage tanks, waste lagoons, non-point source pollution, and runoff. Population growth has also increased pressure, especially in arid Western cities. Population growth has increased demand for water, so cities are increasingly looking at groundwater resources. Land use changes also affect groundwater. They affect rechargeability and the conveyance of pollutants and contaminants. And then of course, climate change. As the climate changes and precipitation changes, what we consider as traditional surface water resources become more uncertain. And so groundwater becomes a more appealing source because of its stability, is seen as a more stable supply. But I think we also have to remember that a lot of these aquifers have a long hydraulic memory, so that the current withdrawal rate will not exceed its renewal rate. And so it may provide a temporary buffer, but long-term, these storage systems may not be available. So moving just into the broad legal framework for groundwater protection, as water law across the United States is very fragmented, both state and federal, and quality and quantity laws are all very siloed. And so between surface water and groundwater as well. And there's a longstanding legal separation legal separation between surface water and groundwater. And it's attributed to the historical lack of understanding of groundwater hydrology I believe there was a case in the 1800s where the judge described groundwater as secret and mysterious and occult. And obviously now groundwater hydrology, we have a lot of advances in technology and information and knowledge of groundwater hydrology, and simply the law hasn't kept up with the science. So in this table, I just kind of laid out in general the different areas of groundwater covered by federal and state. At the federal level, Congress generally has deferred to states, groundwater management to the states. There is some federal interest in groundwater quantity issues, but it generally relates to information, monitoring, contamination, and oversight of aquifer storage and recovery efforts. At the federal level, interest in groundwater quality, there are some 17 federal statutes that address groundwater quality in some capacity, but there is no comprehensive federal legislation to address groundwater quality. And then quantity is largely left to states through their state water allocation laws. So I'm just going to talk briefly about some of the federal water quality laws that apply to groundwater, and then just a real brief overview of some of the state programs, and then tie that all back into how the Public Trust Doctrine can be used to protect groundwater. So the primary federal water law, of course, is the Clean Water Act. And historically, it was unclear that the Clean Water Act applied to groundwater. There was some incidental protection through CAFO regulations. But more recently, the two more recent developments are earlier this year, the current administration promulgated the Navigable Waters Protection Rule, which significantly narrowed the scope of navigable waters protected by the Clean Water Act and specifically excluded groundwater, contrary to the advice of the EPA's own scientific advisory board. So on one hand, you have that relationship between the Clean Water Act and groundwater, but then also earlier last year, there in the case County of Maui versus Hawaii Wildlife Fund, the Supreme Court was faced with the question of whether the Clean Water Act requires a permit when pollutants come from a point source that are conveyed to navigable waters by a non-point source. In this case, a wastewater treatment facility was injecting treated wastewater into groundwater wells for disposal, and some of that treated effluent reached the Pacific Ocean. And the court found that the permitting requirement in the Clean Water Act applies if the discharge is the functional equivalent of a direct discharge from the point source into navigable waters. So that means that this case indicates that a Clean Water Act permit is required for groundwater as used to convey pollutants or groundwater as a point source, whereas the Navigable Waters Protection Rule looks more at whether groundwater is considered a navigable water, in which case the rule says it is not. There are also programs under the Safe Drinking Water Act that protect groundwater quality, specifically the Underground Injection Controls Program, the Wellhead Protection and Source Water Assessments, and the Groundwater Rule. And the Groundwater Rule protects against biological contamination, and the former two are monitoring programs for disposing waste into aquifers, wastewater disposal into underground geologic formations. And then the Wellhead Protection Program just looks at potential threats to drinking water from all sources, including groundwater. And then some of the other federal statutes, which I'm not going to talk about in detail, are the RCRA and CERCLA, and then the Surface Mining Control and Reclamation Act, and then the FIFRA and TSCA also have some groundwater protection aspects. Some of the state laws to protect groundwater, like I mentioned before, water laws are very fragmented, and so the majority of states also have separate agencies for water quality and water quantity, and even that authority over groundwater can be divided among several different state and local agencies. A few years ago, I helped conduct a survey of groundwater managers across the United States, and there were overwhelming concerns about groundwater quality and contamination, and then also about conflicts and declining water level. So among states, there are states with different groundwater management programs. I'll just highlight Arizona really quickly. It has the 1980 Groundwater Management Act, which established ground active management areas where the goal is to achieve safe yield. And so states like Arizona, Florida, and then also California have stronger groundwater protection programs, but this is not consistent across the United States. So just before I turn it over, I would like to say that the Public Trust Doctrine, as you can see, there's a lot of gaps in the legal framework to protect groundwater. And so the Public Trust Doctrine has a very useful gap filling rule. It can fill in the gaps where statutory laws don't reach, and it gives context to statutes, and its common law origins mean that it can't be eliminated or somehow rendered inapplicable by state legislatures. And then also importantly, it creates a compelling narrative. It creates a compelling narrative appeal. So it has deep legal roots, and it captures environmental values and ethics that are timeless and therefore appealing. So I'll just turn it over to James now. Thank you.
Well, thanks very much, Yi. I assume I get to share screen. I'm going to be talking about a case that we did for 10 years. That's how long it took for us to get to a final judgment and decision of the Court of Appeal that was final. Let me bring up my slides. Are we going full presentation mode? Okay. The case is Environmental Law Foundation versus State Water Resources Control Board. 2018 decision, August 29 of 2018, ended those 10 years. The case, let me tell you where it started from. We wanted to, hang on a second, I've got to get my controls here. There we go. What we wanted to do was extend the decision in National Audubon Society versus Superior Court, a 1983 case that is the holy grail of public trust law, at least in California. It's been written about almost more than any other case in the environmental realm because people think it's fabulous. The decision in National Audubon can be boiled down to a simple holding. It involved Mono Lake, which is a world resource in California. Mono Lake is home to a wide variety of fish and wildlife and so forth, recreation as well. The city of Los Angeles had permits from the State Water Board to divert parts of the tributaries that come down from the east side of the Sierra and feed Mono Lake, just as they had done to Owens Lake, which is somewhat further south. And they were basically going to do the same thing. In Owens Lake, for those of you who don't know, is completely dry. LA took all of the water and they turned a thriving agricultural community and lake into a dry lake bed. Having completed their work there, wanting more water, they moved upstream, and they're going to do the same thing. And we're in the process of doing it to Mono Lake, which was slowly dropping. Two important holdings in National Audubon. First of all, the Public Trust Doctrine is not limited to its historical uses in protecting fisheries, navigation. It can also be extended to include ecological study, preservation, recreation, and these are all public trust uses. And so they added, and they said that the doctrine was flexible and could be expanded. Second, they said that the Public Trust Doctrine sits alongside and is co-equal with the permitting system in California, by which people get permits to divert water. Neither one nor the other controls, they have to be harmonized. Third, that the Water Board and other public agencies has a continuing duty to constantly revisit and be aware of how past decisions, including past permits, might be harming the public trust. That was a thunderclap because the permits at issue here that Los Angeles had to divert the tributaries were over 50 years old. and we're serving the community of Los Angeles, the city of Los Angeles, the largest city in the country. And the Supreme Court said, yeah, but if you're hurting the public trust, we might have to take your water away. That was a surprise. And last, the tributaries that were feeding Mono Lake were not themselves part of the public trust. They were not public trust waters because they were not navigable. The public trust doctrine generally only applies to either coastal wetlands that are periodically inundated by tides, and also to rivers, lakes, and streams that are navigable. And the little streams coming down from the Sierra were not navigable. Well, maybe by crazy kayakers, but not by normal humans. So the Supreme Court said, yes, but you have to manage your activities upstream of the public trust water to protect the public trust uses in that water, in Mono Lake. So putting all those together, they said, you've got to slow down your diversions in Los Angeles in order to bring the lake back up to its appropriate level and then keep it there. Which, by the way, Los Angeles managed to do simply by engaging in conservation, mostly low flow toilets over the course of about 20 years. So we looked at that and we said, well, wait a minute, we have a problem in California because groundwater withdrawals have been skyrocketing. California was famously the only Western state which neither monitored, regulated, or in any way controlled groundwater use. It was the wild, wild west. If you could throw a well down, you could suck out the groundwater as fast as you wanted to, even if it dried up your neighbor's well. It was viewed as a property right, and you could use your property in any way you wished, including just sucking the groundwater out. So we thought, well, now wait a minute. If the non-navigable tributaries of Mono Lake can be made part of the public trust, or rather regulated under the public trust so as to protect the surface waters, what about groundwater withdrawals that are from groundwater are hydrologically connected to surface waters? And so we looked around California for such connections. We found it in several different places, but lit upon the Scott River, which is based in Siskiyou County, far northern California. That's where Mount Shasta is, right up on the Oregon border. And sure enough, there was a statutorily determined connection between the groundwater in the Scott Valley and the surface water of the Scott River. And in fact, it had been adjudicated. So the water rights, both for surface diversions and groundwater pumps, had already been adjudicated. So we knew that they were connected, but the adjudication didn't go far enough. It only went about 100 feet, we'll get into the details, but it did not go very far from the river. And so, of course, after the adjudication was completed, like 20, 30 years ago, no, 40 years ago, everybody started pumping, 102 feet from the river. And the river, according to the USGS gauge, literally goes dry every August. You can watch the levels just drop, and that's the irrigation season. So we said, well, no, wait a minute. If the tributaries going down into Mono Lake can be controlled by the public trust, why not the water percolating underground that gets to the river? And by the way, I literally did that with my fingers and my hands in the Court of Appeal. And so we brought a case against the State Water Resources Control Board, which has ultimate authority, and against the county of Siskiyou because they issue the well permits. The question that was eventually presented to the Court of Appeal, and I won't bore you with all the details, but it took 10 years because we had 3 trips to the Court of Appeal before the final one, 2 trips to the Supreme Court on petitions that were denied, and multiple skirmishes and 3 different trial judges. They kept retiring on us in the trial court, but we persisted. We persisted. And so the question eventually presented to the Court of Appeal, the main question was whether the board, State Water Board, has authority and duty under the Public Trust Doctrine, PTD, to regulate extractions of groundwater that affect public trust uses in the Scott. We got them to focus on it. Here are the answers. These are quotations from the Court of Appeal opinion cited. They start with the ringing characterization of the public trust that you see from the Supreme Court, an affirmation of the duty of the state to protect the people's common heritage of streams, lake, marshlands, and tidelands. The trial court, the final decision of the trial court that was appealed from, held the public trust doctrine applies if extraction of groundwater adversely impacts a navigable waterway to which the public trust doctrine does apply. Whew. Thank you, trial court. And then the Court of Appeal took all the, at that point, 9.5 years of litigation and tripped all the way up and down and said, oh, the trial court's finding is unremarkable, well supported by the facts and logic of national audubon. It's like, this is so obvious. Why have you been litigating so long? Because the county of Siskiyou was somewhat recondite. Interestingly, a sidebar, the State Water Resources Control Board, shortly after the litigation was first filed, switched sides. They literally filed an answer that said the Environmental Law Foundation is right. We will not fight them. In many decades of litigating, I have never had a defendant say, yeah, you're right, I'm not going to fight it. So we actually had to scramble for the law books to find out, well, what do you do in such a situation? Thank God we have the county there so we can keep litigating. And oh my God, did they litigate. So we now have a decision that groundwater withdrawals, if they affect surface flows of nearby public trust waters, which again are any navigable water, then there is a duty to protect the public trust uses. And in the course of getting there, the question was raised, well, whether this new law in California that she just mentioned, the Sustainable Groundwater Management Act, or SGMA, which passed as the litigation was going on about 2015, 2014, whether that superseded any possible public trust obligations because it had been codified in statute that needed to be managed, and therefore it just did away with the public trust. That was the county's ultimate argument. And the Court of Appeal held no. Just as in Mono Lake, the permitting system has to sit alongside and harmonize with the Public Trust Doctrine, so too the well permitting and the Groundwater Management Act has to be harmonized. And so in effect, we believe that what the Court of Appeal did is impose upon local agencies as they're developing their local groundwater plans to be reviewed by the Department of Water Resources, they have to consider the public trust if the groundwater is connected to a surface water. So that in a nutshell is what we did. And what I want to leave with this is a final slide, way too many words on it, about all the different ways we think this decision can be applied in the existing regulatory structures in counties or groundwater agencies around the state. And none of this is particularly secret. Option one starts with we're to go after an existing county well permitting system. Options include challenging an existing well or extractor, just as Mono Lake decision went after LADWP's permits, you go after a specific permit. Politically very fraught to be stepping into what's almost certainly a rural county, almost certainly agricultural interests, and do that in front of a local judge. Second, don't go after an existing one, challenge a new well permit application that will have an effect. That's a little easier, feels more like a standard challenge to any permit. Third, don't challenge the permit or the permittees, go after the county. Challenge the county's failure to consider the public trust doctrine when it issues well permits, which I can tell you they all do. They view the issuance of a well permit as a purely ministerial act. Just tell us where the well is, what you're going to make it out of, and how you're going to close it down when you're done. That's it. They just want to know where they are so kids don't fall down. And they have nothing to do with how much water you're taking out or when or what time of the year. They don't want to have any responsibility for that. So we may have to force them to do that. And then the last is if we really want to get their attention, you go in and you enjoin the county from issuing any new permits until they have a public trust regulatory plan in place for issuing permits. And we'll reserve that for the most uncooperative sorts of counties, which will be most of them. Second tack is to use the new SGMA, Sustainable Groundwater Management Act, planning process under which local agencies, which might be counties or water districts, could be all kinds of things, get together and they develop a sustainable water management plan. They then submit that to the Department of Water Resources in California, which reviews them against a list of criteria and procedures and other things that were required by the Act. So those are happening now. The plans are they started getting submitted in 2020. Things got a little slow with COVID, but many of them are now at the Department of Water Resources. One option would be to preemptively go in and challenge the local agency's adoption of its groundwater plan because it didn't consider the public trust. And I can assure you, none of them considered the public trust. Query whether you can do that when it's still under review by the Department of Water Resources and therefore is technically not final. The danger is if you wait too long, by the time DWR is done, the statute of limitations against the local agency may have passed. So one's betwixt and between. Second, go to DWR before they start reviewing all these plans and tell them they have to include public trust in reviewing the local agency's plan. Not just the criterion sigma, but you got to have public trust. That one we have already done. We did that last spring. We've not heard back from DWR whether they are doing that or not. Again, COVID. But they at least have it in front of them and they can't say they didn't know. And then third, of course, if DWR approves a groundwater management plan that has no public trust in it, then we go after DWR for its failure to include public trust in its review. So those are the different options that we think we have. I think I brought that on time under budget, and I'm ready to turn it over to Brent.
Right on. Thanks, Jim.
Absolutely.
Thanks, E. And I want to take a moment to thank Lisa and Claire for putting on behalf of all the panelists, putting on this program, and all the Oregon law students that are working on a COVID-friendly conference this year. Thank you very much for all your time and work. So I'm going to talk about a case that has been going on for a couple of years now in Iowa. Share my screen. There we go. So Iowa Citizens for Community Improvement versus State of Iowa. Now, while Jim was talking about the Environmental Law Foundation case involving groundwater in the Public Trust Doctrine, this case involves surface water in the Public Trust Doctrine. In Iowa, corn is king. It's the #1 state in terms of corn production. It is the #1 state in terms of hogs. And that means that there's a lot of fertilizer and a lot of hog manure placed on farmland that runs off into surface water systems. The Clean Water Act exempts agricultural stormwater runoff from the permitting system under the Clean Water Act, and it defers to states to decide whether to regulate that type of pollution. Of course, most states do not, which is why agricultural sources are the leading cause of surface water pollution in the United States. Here's a shot of a tile drain system emptying water from a field. You can see the drainage ditch here. This is how the pollutants, nitrogen and phosphorus, run off of agricultural land and enter waterways through stormwater runoff through these tile drain discharges. Now, this case involves the Raccoon River watershed. This is a wholly interstate watershed in Iowa. It's a tributary to the Des Moines River. The Des Moines River and the lower segment of the Raccoon River are meandered waterways, which in terms of the Public Trust Doctrine, make them navigable waterways and subject to the doctrine. These are tributaries to the Mississippi, and all of this nitrogen, phosphorus, it runs downstream into the Gulf. The dead zone is about the size of Massachusetts, off the coast of Louisiana, and Iowa has 5% of the land area in the Mississippi River drainage, but it contributes 30% of the nitrogen that causes the dead zone. The Raccoon River watershed is the 4th most significant watershed in terms of nitrogen going to the Gulf. But the Raccoon, besides affecting the Gulf, is affecting the drinking water of the 500,000 Iowans who live in Des Moines. The Des Moines Water Works provides water to 500,000 Iowans from the Des Moines River and the Raccoon River. And the problem with that is that the Raccoon River has been trending up over the last 40 years or so in terms of its nitrate levels. Right now, the Des Moines Water Works has the world's largest nitrate removal system. It must treat this water in order to bring it under the Safe Drinking Water Act 10 milligram per liter nitrate limit. The other water pollutant that's of concern in surface water systems, increasingly so because of climate change, is toxic blue-green algae, cyanobacteria. Typically, cyanobacteria forms in lakes, but more recently, cyanobacteria has been forming significantly in the Des Moines River and in the Raccoon River. The last 2 years, there has been so much cyanotoxins in the Des Moines River that it's been unusable as a drinking water source. This summer, there was so much cyanobacteria in the Raccoon River that it was clogging up the Des Moines Waterworks treatment systems. So Iowa Citizens for Community Improvement and Food and Water Watch, by the way, one of my co-counsel with Food and Water Watch, Tara Heinsohn, is in the audience here, and I want to give Tara a shout out for all she's done on this case. They've decided to sue the state of Iowa because the state has this public trust duty. And instead of protecting the public's use, the state has a voluntary system of limiting agricultural water pollution that's not working. It's called the Iowa Nutrient Reduction Strategy. And the state in 2018 doubled down on this voluntary system, the system where they exempt agricultural sources. And they said that the voluntary system was the official policy of the state for controlling these harmful nutrients. So Iowa Citizens for Community Improvement and Food and Water Watch, represented by Public Justice, brought an action against the state of Iowa under the Public Trust Doctrine because Iowans have a right to clean water. Now, a case called the Sorensen case, very similar to the National Audubon case that Jim talked about the public's rights and the scope of the doctrine. And it's about public use, not access. It's about use. And the uses for the public are unbound. Recreation, drinking water, navigation, swimming, even hiking along the side of a river is the type of use that is included in the Public Trust Doctrine. And Iowa is unique in the sense that it has several constitutional provisions that bring the public trust right and duty within the Iowa Constitution structure. And one is the Unenumerated Rights Clause, which brings in pre-existing common law rights that existed before the state became a state. And of course, the Public Trust Doctrine goes all the way back to Roman law. It goes back to English common law and the Magna Carta, to when the 13 colonies were English colonies before they were states. And when Iowa became a state, the act bringing Iowa into the Union conditioned its admission to the Union on that public use right being forever protected. And the Iowa Constitution doubled down on that by making it an unenumerated right. It's also been recognized as a property right, the deprivation of which violates the substantive due process clause of the Iowa Constitution. So the framing of the case is both as a constitutional claim, the violation of these use rights protected by the Unenumerated Rights Clause and the substantive due process clause, but also as a common law claim. The current status of the case is at the Supreme Court. Once we filed, the state brought a motion to dismiss, challenging the standing of Iowa, CCI, and Food and Water Watch, claiming that the political question doctrine barred our claims, that they were basically arguing that the state legislature and executive branch held all authority, and there was no business for the judiciary to question their decisions. And then they also want to say that we should have filed an Iowa Administrative Procedure Act case. The Supreme Court granted their application for interlocutory appeal, and the case was argued a little more than about a month ago. With that, I'll turn it over to my co-panelists, and if there's any questions more about the case, I'll do the best that I can to answer them. Of course, it is pending litigation, so I may have to keep my comments limited.
Brett, I can't help but jump in for a moment. They made exactly the same argument in our case involving the Scott, that the courts had no role in doing the public trust, that the all power rested with the trustee, and the trustee was the legislature, and the courts had no role whatsoever, which is remarkable. Since at least in National Audubon, it was quite clear the courts had the primary role in protecting the public trust. But they at least in our case, of course, they want to get it away from there because then they can have more control over the politics.
Absolutely.
Okay, thanks, Brent. And just to echo your thanks to Claire and Lisa and all the students with land, air, water at U of O, and for putting on this virtual PILC this year and kind of rebooting this panel from last year. So it's I'm really glad we have the opportunity to finally gather, albeit remotely, to connect about protecting groundwater resources. So I will share my screen and get everything all set. 1 second. Okay. So I am going to take a slightly different track and talk about a research project from this last year that considered how state water law can advance the principles of the Public Trust Doctrine, and specifically principles of sustainability and intergenerational equity. And I want to take a brief moment and just thank the ENR Center, where this project was worked on, and all the student fellows that a lot of them are on the call today, and Professor Adele Amos and the staff at the ENR Center, and they had a big hand in helping draft this report. So just thanks to everyone and acknowledging everyone's work on this. So as I said, this report looked not at the Public Trust Doctrine as an independent obligation on a state as trustee to manage the trust resources, but instead considered how these principles that underlie the doctrine, and specifically sustainability and intergenerational equity, how state water codes have already integrated those principles that advance regulations that advance those principles in the water code, and how those new revisions to state water codes could further advance those principles. And the benefit of incorporating these public trust principles into state water code is at least two-pronged. So first, by integrating them into water code, you provide a procedural mechanism that advances the principles of sustainability and intergenerational equity into state regulatory decision-making. And these provisions can establish goals and policies that direct agency decision-making. They also create procedural obligations that allow for citizen engagement in the management of water resources. And this can be particularly important in states like Colorado and many other states that don't recognize the Public Trust Doctrine as applicable to water, and then particularly to water that has been allocated through a state appropriation. The second is the inclusion of the Public Trust Doctrine considerations in regulatory schemes may provide a further basis to support the development of common law public trust doctrine in the state. So for example, in Hawaii's Waiahola decision, the court cited the state's water code as a basis for recognizing the public trust doctrine in the state. And then similar, recently last year, Nevada Supreme Court's opinion in Mineral County also relied on legislative statements in the water code with respect to the water being a public resource and the management of that resource for the public interest as a basis to find the public trust doctrine applicable to all waters in the state, both navigable and non-navigable. While the project hopes to more broadly inform revisioning of a wide array of natural resource management frameworks, water codes were selected as an initial research focus for several reasons. Let me get my slides going. So and these reasons include, they're listed here. One is that water's been always understood to be imbued with kind of a public trust obligation, being having the attributes of a public resource. Second, water rights have always straddled the line between public rights and private use. So when you get a water right, you get a right to use the water, but the general concept is that you would not be getting a right to the water itself. So you can't privatize water. And then drawing from these first two, the third reason is that water codes have already begun to integrate considerations of the broader public interest and the environment into water frameworks. And I'll add two more considerations that aren't on this slide. And those are that water is managed at a state level, as you mentioned, and that provides a wide variety of regulatory approaches to analyze, and a corresponding number of opportunities really to advance this work and further advance the integration of these regulatory mechanisms into state water codes. And then lastly, and particularly in Western states, adopt the prior appropriations system, so first in time, first in right, a seniority system. They're an interesting study area to consider the effectiveness of regulatory approaches that seek to protect public trust values. These systems typically require rebalancing and reprioritizing resource use, and management, as the systems were founded and based on conflicting principle of prioritizing resource development, consumptive use, and are often already over appropriated. And then you have the added challenge of the specter of private property interests that arise with state authorized water rights and can raise takings liabilities when if the state tries to reallocate that water. And then so the project looked at 4 specific states: Colorado, Nevada, 2 in the western half, and then Michigan and Virginia in the eastern half, and analyzed those states for these 5 different components. Kind of look generally at the water management framework. How does the state manage water, prior appropriations, riparian system. It then looked at provisions for managing and regulating groundwater specifically, the inclusion of public interest considerations in management decisions, mechanisms to protect non-conceptive or in often terms environmental flows, and then comprehensive planning tools for engaging communities. So does the state have policies or practices where it looks holistically at water management in the state? From that research, we identified 9 key elements of state water code that could advance public trust principles. And they're listed here, and I'm not going to go through all of them. It's important to note that these principles are drawn from the 4 surveyed states, and there are certainly examples from other states and even internationally that could yield other effective approaches. Using these 9 elements, we developed a chart for each state, and it kind of runs through where in the state's particular water regulations these types of provisions might exist. And I should mention the report is on the ENR's website and has a lot more detail than all of this, so it's available there. And while we didn't parse out in the report groundwater and surface water and how each of these provisions impacts the individual resource, for this presentation, I'm going to focus the remainder of my time on a few examples of elements within groundwater management frameworks. I know we don't have much time left, so it's going to be a pretty high level overview of just 3 of these, and then and there will also be a focus on Nevada, but don't take that as indicative of a lack of these provisions in other states. So they exist in other states, and there were many examples of unique ways states are kind of integrating these considerations into their water management. So the first provision I'm going to highlight is the perennial yield or safe yield. So the requirement that you manage the resource within the safe yield of the resource, or limit the amount in the groundwater context of withdrawals the amount that won't reduce the aquifer level below its amount of recharge. And the concept of sustained yield or limiting appropriation of the capacity of the system in water law is commonly found within the groundwater context and not the surface water context. This slide is from a clip of a long-running Nevada case addressing groundwater applications by the Southern Nevada Water Authority serving Las Vegas, excuse me. And among the issues in this case was whether there was enough water available for appropriation in the aquifer. And while not an exact parallel to the safe yield concept, there's a few nuanced differences. Nevada caps use at the perennial yield of the aquifer, which is defined as the maximum amount of groundwater that can be salvaged each year over the long term without depleting the reservoir. And typically that amount cannot be more than the natural recharge of the groundwater. Among the basis for reversing the state's decision to authorize water use was that the perennial yield requirement, that there was not enough water in the aquifer and would exceed natural recharge, and then also statutory requirements around a public interest review, and that the appropriation couldn't be against the public interest. And while the sustained yield is often thought of in the groundwater context, I'll just pause to note that it has the potential to be a forceful tool in the surface water context as well. For instance, reconsidering how states determine water availability when they consider new appropriations. So while not precisely analogous, Michigan's water system ties water availability to a concept called an adverse resource impact that caps water use at levels that will not degrade the resource. And that's measured based on impacts to fish population. And using this metric, they end up with what's akin to a base flow in the surface water that can't be, the water allocations can't lower the resource below. So a second element is the ability to reserve water for non-consumptive uses, such as environmental flows. And you usually see this in the surface water context with in-stream flows. But Nevada recently adopted a requirement that calls for the reservation of 10% of an aquifer's perennial yield. And following the bill's passage, the state engineer actually entered 89 interim orders implementing that bill. It's important to note a limitation with this, just as it is in the surface water context, is that it suffers from the same implementation challenges for areas that are already over appropriated. So it's not reallocating water that's been appropriated already. It's relying on the existence of still that water in the aquifer, and then it removes it from future appropriation. And then the last element I want to flag is the ability to address overuse and bring a system back into sustainable levels of use when it's already been over appropriated. And so these provisions are also frequently found in the groundwater context. This first article is from Virginia. And in Virginia, groundwater use only requires a permit in groundwater management areas. And there are 2 currently in Eastern Virginia. The ones designated large quantity users require a permit. One key feature of this program that makes it unique is the ability to designate areas not just after over allocation, but also in areas that could face overpumping. And so this precautionary approach is one that might be copied in other regulatory frameworks. Also, interestingly, Virginia permits have terms and authorize the state to come back and modify or even revoke the permit in a variety of circumstances, including if it endangers the environment. And so this article is describing a situation where Virginia used that authority to reduce the water withdrawals of 14, I want to say, large quantity groundwater holders that constituted 80% of the permitted groundwater withdrawals in that groundwater management area. And they reduced that by 52%, which is the equivalent of about 69 million gallons. And this was through a voluntary agreement, but spurred in part by the state's authority to kind of have this backstop when they realize if after the fact the permit's causing environmental harm. And then I'm going to briefly just mention another one from Nevada. I know I'm up on time, but this slide is about the Diamond Valley, which is Nevada's critical groundwater management area. And Nevada adopts a system, although they regulate groundwater withdrawals through the state, where there is 10 years, where there is a consistent over pumping, they have the ability to designate special areas that then allow the state to be more restrictive in their management. For critical groundwater management areas once designated, the water users have 10 years to reach agreement on how to reduce those pumping levels, or alternatively, the state will come in and curtail water use in order of seniority until it can reach sustainable levels. There's some ongoing litigation around how that provision is being implemented and the flexibility it gives to communities to use voluntary restrictions to meet the statutory requirements. But either way, that designation of a critical groundwater area gives the state the ability to return the system to sustainable levels of use. And then I want to just briefly highlight the Mineral County decision in Nevada as an example of how the integration of public trust principles in water code impacted the application of the public trust doctrine as a common law doctrine in the state. And so the case involved Walker Lake, and if you take kind of a straight line from Sacramento east, you'll hit Walker Lake, and Walker Lake was suffering from, similar to Mono Lake, severe water decline, level declines causing water quality problems as well. So there's a lot of ongoing litigation about how to address those issues. The Ninth Circuit certified to the Nevada Supreme Court a question about the scope of the public trust doctrine in the state, and relying in part on the legislative recognition of the public trust and the water as a public resource in the state. The court found that the public trust doctrine applied to both navigable and non-navigable water, presumably including groundwater. Ultimately, the court held that despite the public trust doctrine applying to all these waters and also waters appropriated under the state's water code, that the state's water code's provisions, including those restricting beneficial use, prohibitions on waste, requirements that the use be in the public interest, and then authorizing the state to curtail water use in basins that are over allocated, satisfied the state's ongoing duty to ensure that the resource use was in the public benefit. So there's kind of a trade-off. They recognized really broad public trust, but they also found that the state's water code was sufficient to meet those. And so relying on a kind of hoping for a robust public trust principles in the water code to meet those requirements. So I'm going to give you one last slide just to really thank Northlight Foundation for funding this work. NRDC was a partner. And then again, I can't thank all the student fellows enough. So thank you. I have to stop sharing my slides.
Thank you, all you panelists. That was great. We're going to, if people want to stick around for a few minutes, if we can do like a quick Q&A. So if any viewers have any questions, you can use the Q&A function down at the bottom of the screen to ask any questions.
That's great. While they're doing that, if I might, I noticed in the participants list, there are two people that I feel I must give a shout out to. My co-counsel in the Environmental Law Foundation case, Glenn Spain, with the Pacific Coast Federation of Fishermen's Associations and Institute for Fisheries Resources, which was our co-plaintiff, and we thank him from the very beginning of the journey. And also Professor Rick Frank from King Hall at the University of California, Davis. They were my co-lead counsel in that long journey.
Doesn't seem like we have any questions coming into the Q&A yet, but I noticed there was a question in the chat during the presentation that you answered, James, I think, if you want to talk about that a little bit.
Yeah, somebody asked whether you should do a petition for rulemaking to the state to require consideration of public trust when they review the plans, to give another administrative law argument if the agencies don't address the public trust. And my response was, you don't need to do a petition for a rulemaking to require them to consider the public trust. I would worry that'd be a kind of a cul-de-sac and lead you down a place you don't need to go, because the courts have held, at least in California, the obligation to protect, or at least to consider, the public trust and protect it when feasible is imposed by the public trust itself, and it does not need any additional statutory or administrative law requirements to do that.
And to add a little bit to that answer, you know, depending on what state you're in, you know, filing a petition for rulemaking puts your argument, puts the factual construct in an administrative law type environment where the court will defer to an agency's findings, and that may not be the politically, you know, advantage. The political winds tend to blow, you know, against you and support the polluters. So, so getting in a situation like that, you know, you may not end up with the best facts or way to frame up your case.
Well, if there aren't any questions coming in, then I'll just thank you panelists one more time. And thanks everybody for coming. We have the session recorded also, so if anybody missed it and wants to watch it sometime, I'm sure we'll have it posted. So thanks everybody.
Thank you, Claire.
Thanks, Claire.
Right, we all go to the reception now? Is there a reception someplace?
Yeah, drinks.
Come on, it's cocktail hour.
Oh, we did actually have one question come in, so I guess some people are leaving, but you guys could answer it. Are there public trust implications for irrigation district governance? So could outvoted minor users claim that major users were violating the PT by implementing infrastructure, say a dam, that would deprive them of water?
And I assume you're asking for a friend?
Mm-hmm.
Boy, that's a good one. I tell my students in my my journalism law classes that the correct answer to all legal questions is it depends. And here you would have to find out who's using the water for what purpose first, because there are these public trust uses that are favored. And you can have a clash between those, and then the trustee gets to decide which one to use. But the public trust uses, oh God, can I use this word? Trump. They supersede non-trust uses. So without knowing more about the facts, I don't know. Interestingly, and it's worth pointing out, the California Supreme Court in the National Audubon case specifically held that domestic uses of water, pulling water out to use it for domestic use, was not a public trust use.
So it looks like we actually have one more question after that, and it says, can the panelists speak to any reflections they have about causality? I'm thinking of causes where they may be multiple upstream impacts that may have minor impacts / de minimis impacts. In the California case James mentioned, it seems like the upstream uptake was more clearly negatively impacting the lake downstream.
That's a really interesting question. Multiple upstream impacts, minor downstream. Yeah, I don't know the answer to that one. Yeah, Lisa, can you answer it?
I don't think I can, no.
Okay.
As a 1L law student, I don't think
no,
I have all the.
It appeared on the screen, says you would like to answer the question live.
Oh.
So I was deferring to you. Okay.
I was just clicking on it so you could see it.
Yeah, that'd be counterfactual to the Mono Lake decision. In our case, the Scott case, because the posture it ended up in, we ended up not going down a factual route of deciding whose wells were causing the problems. We simply wanted the legal question answered. But you'd have to have some impact on the flows and the public trust uses to apply the public trust doctrine to a non-navigable water, such as a tributary. Mm-hmm.
You might look to the Maui County case. It's not the same framework, but in that case, they were tracking kind of where the input was and how that impacted So they were tracking, they were doing kind of some of that work of trying to link back the final impacts on the sea to the initial discharge into the well. And so it may be some of that causality is in that case and how you might work on that. But I don't know how that ties to the public, to a case where you were trying to demonstrate that in a public trust action.
Yeah, yeah. And Hawaii's got its own, I mean, it's an island, you know, it's not getting water from any place else. So they have to deal with their water resources quite differently.
Great. Well, thank you guys. I'm gonna
Thank you.
stop the recording.